Ganatra, Senior Assistant Prosecuting Attorney for the People.
Assistant Public Defender with and on behalf of Miss Dejour Exton, who appears to my right. Can you state your name for the record, please?
Dejour Exton.
Thank you. Your Honor, today's the date and time set for a probable cause conference. My wishes are to proceed and move forward with this matter. I spoke with Mr. Ganatra earlier this week. He wanted to go over the progress report from Ms. Exton.
Go over what?
Do you have a copy of that? It's dated March 12th.
I have a few extra.
I don't. Let me see. No, I don't have a. We've got to figure that out. Because
The council has an extra copy.
I do, Your Honor.
Sharing the report.
is she on a benzo?
Yes, Your Honor. She's prescribed that medically.
On 3-5, why do I have a missed test?
Your Honor,
Because, and I'm just going to place that in context, because on February 29th, because we had all of those missed tests before, I had indicated there was to be no further missed test.
exactly, Your Honor.
So why did she miss a test, Mr. Allen?
Your Honor, if I may, if you recall, Ms. Exton appeared at that probable cause conference via Zoom. I put on the record, I let the court know that she had a funeral arrangement set up on the 4th of March. Ms. Exton, outside of her 2-year-old daughter, who's at home right now, there might not be anyone she loved more than her grandfather. Her grandfather was buried less than 24 hours from the time she was supposed to test on the 5th of March. So she called community corrections, she spoke to the agent, and they arranged her to test on the following day, which she did.
Right out of the gate, this case already has the courtroom balancing act that judges deal with every single day: accountability versus humanity. You've got Miss Exton standing in front of the court after missing a required test, and on paper, that sounds simple. Miss the test, violate the condition. But then the defense starts laying out the context: a grieving granddaughter, funeral arrangements, emotional exhaustion, financial pressure, and a 2-year-old child at home. And suddenly, what looked black and white starts getting complicated fast. Now here's what makes this interesting. The judge isn't immediately exploding over the missed test itself. Judge Simpson is trying to determine whether this was irresponsibility or a legitimate life circumstance handled the right way afterward. And according to the defense, she didn't disappear, didn't dodge supervision, and didn't avoid accountability. She communicated and completed the makeup test the next day. But in these bond situations, consistency is everything. Courts watch patterns. One missed test can become a major issue depending on how the defendant reacts afterward. That's why the attorney is working overtime here, trying to frame Miss Exton not as someone ignoring court orders, but as someone overwhelmed and still attempting to comply.
Yeah, and I believe this is about the 7th probable cause conference Ms. Exton has appeared for. At this point, she is mentally and physically wore down. And how I know this is because I've had the pleasure of getting to know Ms. Exton, getting to know her family. I've spoken to her father. I've spoken to her grandmother. Every time I call her, she responds. If she doesn't answer, she calls me right back. 90% of the time I speak with her 2-year-old's in the background, laughing and screaming. And she's just, Your Honor, what I'm trying to say is I would be here all day if I had to tell you how much Ms. Exton has gone through. She is financially struggling as a single mother with a 2-year-old at home.
I understand all that, counsel.
Your Honor,
My issue is the missed test.
And Your Honor, this goes to the missed test. She just buried her grandfather. She has been on bond testing for 5 months consecutively. Every result that is on that bond form she's medically prescribed to. And when she misses tests, she's communicative. I truly believe that progress reports are subjective. And
Subjective in what way?
if you look at the circumstances here, the effort, the totality of testing for all these months, is she perfect, Your Honor? No, absolutely not.
And
And
why am I getting this long argument? I just asked about the missed test. I think you've given me that answer twice. That's the only thing I asked for.
And there it is, the exact moment Judge Simpson pumps the brakes on the emotional defense strategy. Notice what just happened here. Defense counsel tried to broaden the conversation into grief, hardship, parenting stress, financial struggles, and overall compliance history. But the judge snaps the focus right back to the missed test itself. That's courtroom control. This is something viewers need to understand about probable cause conferences and bond supervision hearings. Judges often separate sympathy from compliance. Judge Simpson is basically saying, I understand life is difficult, but answer the specific violation first. And honestly, you can hear the frustration building because he says he already got the answer twice. Now, to be fair, the attorney is clearly trying to humanize his client. That's his job. He wants the court to see a struggling mother instead of just a missed test report. But Judge Simpson's response tells you he's worried the explanation is becoming an argument instead of a direct answer.
Your Honor, I'm just trying to explain to you why she missed that test. There's a lot going
Well,
on.
I know you explained to me her grandfather's a funeral and that she made a makeup test.
Yes,
So you had to point me to.
I just want to protect my client. That's all. I'm trying to move this case forward. Sorry if I overstepped.
Mr. Nacho, was that what you wanted addressed? The missed test?
Yes, Your Honor. And I will acknowledge there was an offer made, which is open, and it will be honored at some point. But counsel asked about writing up the offer for today, knowing that this progress report specifically alleged actions by the defendant which were in violation of the court's stated order for 29, which this report even acknowledges in there. It's the last sentence on the report. This court ordered only this test, and that's what happened. I told them that I wasn't going to bring that plea offer today because I wanted the court to address this community corrections issue before I did a plea. And it's worth noting the next day there's an abnormal creatinine.
Yes.
Which is not very significant, but I'm just going to defer to the court on that because it's the court's order. That's what I wanted to bring to your attention today.
That could be anything. That could be.
Exton, if I put this out 3 to 4 weeks, can you make every test
Yes,
and not miss a test?
yes.
This exchange may sound simple, but legally, it's huge. Judge Simpson basically gives Miss Exton one clear path forward: prove reliability over time. No speeches, no emotional arguments, no complicated legal maneuvering, just compliance. When the judge asks, can you make every test and not miss a test? That's the court offering a final credibility checkpoint. And her immediate yes matters because now the expectation is crystal clear moving ahead. If future violations happen after a warning this direct, courts usually become much less forgiving. What's also important is the prosecution quietly revealing there's already an offer sitting on the table. That means this defendant potentially has an opportunity to resolve the case favorably, but bond behavior can absolutely impact whether those offers stay available. Judges and prosecutors constantly evaluate whether defendants are taking supervision seriously. And notice the judge's solution here: adjournment. He's not revoking bond. He's not escalating punishment. He's effectively saying, I'm giving you time to prove yourself. That's actually a significant break considering the court already flagged concerns about violations and abnormal testing.
I'm going to adjourn the probable cause. So hopefully you'll be able to take advantage of any offer they made to April 11th, 2024, 9 a.m.
Thank you so much, Judge.
And I'm just gonna indicate no further mistests for any reason.
Okay. Thank you.
Thank you.
Court calls the case of the people versus Diana Johnson.
After one of the people. This is public defender and Johnson. Johnson, will you state your name for the record?
Diana Johnson.
Thank you.
Your Honor, to the concept for the first probable cause conference this case, I'm asking for an adjournment where we requested some video discovery that I still need to review.
April 4th, 2024, 9 a.m.
Thank you, Your Honor.
Bond will
Thank you.
continue. Thank you. Court calls the case people versus Bruce Jones. Your name? My name is Bruce Jones. Senior counsel. This is a PD case. Stepped outside. Where'd she go? She knew she was cutting her case called. Come on, get up here. Client's been waiting an hour.
Sorry, Your Honor. This is Bridget
You gotta
Coons.
apologize to him. He's the one that was saying bad things about you.
Sorry.
I was covering you. Yeah.
Your Honor, Bridget Coons on behalf of Mr. Jones. At this time, we would be just requesting a 1-week adjournment if possible. I got the video. I haven't had a chance to review it yet.
I give you, and then he's got to see it. right?
Yep.
So why don't I do this? Probable cause conference, April 4th, 2024. 9 a.m. bond will continue. All right.
Thank you.
sir. Thank you, sir.
One thing Judge Simpson is doing consistently throughout these hearings is rewarding preparation and honesty while keeping the docket moving fast. In this case involving Bruce Jones, the defense attorney admits she hasn't fully reviewed the video evidence yet and needs additional time with her client. And instead of turning it into a confrontation, the judge handles it efficiently because the request sounds legitimate and organized. But there's another subtle courtroom dynamic happening here that people often miss. Watch how the judge reacts differently when attorneys are straightforward. Compare this tone to earlier moments where he felt answers were getting stretched or over-explained. Here, counsel says exactly what the issue is, discovery review, and the court immediately works towards scheduling. That little joke about the client waiting an hour and counsel stepping outside? It lightens the room for a second, but underneath it, courtroom timing still matters. Judges notice professionalism, preparedness, and whether attorneys respect the process. And honestly, hearings like this may not sound dramatic on paper, but they're part of what separates stable cases from chaotic ones. When evidence is being reviewed properly, when adjournments are requested transparently, and when bond conditions are maintained, cases tend to stay manageable. Once confusion, violations, or credibility problems enter the picture, everything escalates fast.
Court calls the case of people versus Maurice Jones.
Bridget Coons on behalf of Mr. Jones.
Maurice Jones. What are we doing?
Your Honor, we'd like to set this one for a preliminary examination.
Well, you see the bond violation report?
I do. So I did have the opportunity to talk to Mr. Jones about this. He does have his medical marijuana card.
Okay, does he have a medical cocaine card?
He does not. Whenever I spoke to him about it, he did inform me that he is retesting for those. Based on he is retesting for the March 11th or sending it into the labs. Whenever we discussed it, he explained to me that he did have another test done. His test came back negative. Okay, a 12 panel. His test came back negative, but the Lenawee County came back positive. So he is disputing that.
His test came back
negative.
Now this hearing just shifted into full credibility warfare. Maurice Jones is trying to convince the court that repeated cocaine positives across multiple months are somehow false results, contaminated tests, or part of some setup happening at the testing location. And Judge Simpson immediately starts drilling into the timeline because the numbers are becoming impossible to ignore. This is why consistency matters so much in court-supervised testing. One disputed result? Maybe the court listens carefully. But when the judge starts listing positive dates month after month after month, the explanation becomes a much harder sell. And you can hear Maurice trying to build a narrative in real time. He's talking about bringing his own panels, taking separate tests, getting different results, even involving witnesses. The issue is that courtroom credibility usually depends on documented procedures, official confirmations, and verified retesting, not just personal belief. Meanwhile, Judge Simpson is staying surprisingly patient here. He's allowing the defendant to explain himself at length, which not every judge would do. But the dangerous thing for Maurice is that every additional explanation raises another question the court can examine.
Which test?
From my understanding, it's the March 11th, correct? And then did you also do that for the January 31st?
Yes.
Yes.
Well, the previous ones that I violated on, I wasn't,
Okay, before you go on, okay, I'll let you go and explain anything you want to explain. I don't have a problem with that. However, looking through your report, you continue to test positive for marijuana, but from September 2023,
yes,
there was cocaine in your system.
yes,
November 11th, 2023, cocaine in your system.
yes,
December 18th, cocaine in your system. January 31st, cocaine in your system. March 11th, cocaine in your system.
I'm only think about it. It's a cop where I'm testing that.
Pardon?
Where I'm testing that in Lenawee County. It's a cop with other matters I'm dealing with, and I'm going through a thing right now where they're setting me up. I started bringing my own panels to the place that I drop at. They use a dip thing, and I use a urine test, and my test came back up negative, and the they test came back up positive. And I'm telling them I never even did cocaine. And I ain't even about to sit right there and try to justify it in court. That's why I accepted one of the violations. But Fresh Harbor told me if I honestly didn't do it, fight it. And I never even did know. And it have to be in you. I looked it up, I read about it. So now I started going in there and taking my own test. And I have witnesses with the people that I took the test with at the place just on the 11th. That mine showed negative.
I just gave you all of the dates that you tested positive for cocaine.
No, but I wasn't smart enough to,
I just gave you the dates that you tested positive for cocaine. You're telling me that all of those are
negative.
All of those are wrong?
Yes, all of them. Every last one of them. And I won't sit right here and lie to the court. But I did accept.
You want me to call over and get the levels of cocaine that were in your system? Because they have them.
But I've never used in my entire life, ever.
What makes this exchange so intense is that Maurice Jones is not giving the kind of cautious, lawyer-filtered answers courts usually hear. He's emotional, detailed, frustrated, defensive, and trying to argue logic directly to the judge himself. From his perspective, he's saying, why would I repeatedly appear for testing, never miss appointments, and still intentionally use cocaine? That's the core argument he's trying to sell. He believes his consistency with showing up proves innocence. But here's the legal problem. Courts often view attendance and clean behavior as separate issues. A person can consistently appear for tests and still test positive. So while Maurice thinks his logic clears him, Judge Simpson is focused on the documented results themselves. And notice how the defendant keeps escalating, emotionally, bringing up witnesses, photographs, home tests, conversations with staff, and personal promises that he's never used cocaine. Those kinds of statements may feel persuasive emotionally, but judges usually rely more heavily on official testing protocols and repeat documented outcomes.
And that's why I wasn't smart enough in the beginning with buying my own tests to go there. I was using them at home. But then on the 11th, I told myself, like, why am I doing them at home? I need to be doing it in front of the people so they can see that blah, blah, blah. And then the person that tested me there, I dropped with mine and he tested me with the dipstick, and the dipstick showed that I was positive and my test showed I was negative. And he took a picture of it. I got photos of it. His name is Mike. And I never use, and I won't sit right here and lie to the courts when I drop twice a week for the last, I don't miss a test. So why would I actively use cocaine once a month? I'm from Detroit. Why would I actually use cocaine once a month if I'm an active user? And then I'm going to every court day. I'm going to every schedule. I don't miss one. I'm saying I don't miss a drug test.
You don't know Shakespeare, do you?
No. I just don't miss a drug test. So I wouldn't come to your court and tell you to your face that I don't do it, but I haven't missed a drug test, but I'm doing cocaine. Like they setting me up, and I'm trying to handle the situation, and I am handling it with the lawyer. I talked to her, and she said she can help me with the matters of up there, but I'm testing there, and they're setting me up. And that's all I can say. Other than that, I've never used in my life, and that's on my son, my mom. But anyway, I've never used in my life, ever. Not, me, nothing, ever, nothing.
You done?
And I ordered a swab, like, cause once you drop. Okay.
Your Honor, I advised him that if he wants to dispute them in the future, he has to do that with the Lenawee County, basically send it in for testing.
That Lenawee County did what?
That he would have to send it in for testing if he wants to dispute that in the future.
Is he taking them here or in Lenawee?
In Lenawee. And then it's basically getting sent to the community corrections here.
Mm-hmm. I don't know. I probably looked at what seems like probably 1 million of these. The odds of this happening are like nil.
This is the exact moment the courtroom tone changes completely. Up until now, Judge Simpson was listening, questioning, and giving Maurice Jones room to explain himself. But when the judge says the odds of this happening are like nil, he's signaling something critical. The court no longer views this as a misunderstanding. It's starting to look unbelievable. And that's devastating for a defendant in a bond violation situation because credibility is everything. Once a judge thinks someone is stretching the truth, every additional explanation starts sounding worse instead of better. What's also important here is the procedural issue surrounding the retesting. Maurice keeps insisting the sample was supposed to be sent out, but when the judge presses him on whether he actually confirmed that process happened, the answers become shaky fast. Suddenly, it changes from "it was being handled" to "I thought it was being handled." And in court, assumptions can destroy an argument.
So when are they supposed to have the results of the test from the 11th?
We received any information for that?
No, you just told me I had a violation for it.
Has he ordered a retesting of that sample?
Have you, besides the original test?
The one on the 11th?
Yeah.
Yeah, well, with the dude, Mike, the new dude. Yes, he took
What?
Yes, with the new dude, Mike. He took a picture of my tests and was supposed to send them in. And it cost $60. Yes.
You took a picture of your test.
Of mine in the test, sent it to the probation officer or the bonds officer, and yeah, they were supposed to send it out. But I never even knew I had this violation. Because when I left out of the place, we was all good. He would have told me that I dropped positive, and he never told me that. And I stayed there until all my tests is clear.
So why is it being sent out to be retested?
Yes, it should be. And if it's not,
well, hold on. What do you mean it should be?
Did you pay the?
Did you do it?
He never told
Did you do it?
No, because he never told me that I was.
Hold it. I just thought you told me that he did.
I was under the understanding he did. I think that he might.
Yeah,
be
well, that's what
confused.
he also said in his little soliloquy he was giving.
No, I know. He told me I was good. He said he would handle it. If he said if Darren said something that he was going to handle it. So I ain't press the issue because I knew I was clean and he seen it on the thing. So he told me I could win.
This exchange right here is exactly why courtroom communication has to be crystal clear when someone is under supervision. Maurice Jones is trying to explain why he never personally followed through on the retesting process, but every answer seems to create even more confusion. From the judge's perspective, this is simple. If you genuinely believe multiple cocaine positives are false, why wouldn't you aggressively verify every disputed sample immediately? That's the logic Judge Simpson keeps circling back to. Meanwhile, Maurice is describing a much looser understanding, basically saying he trusted someone at the testing facility to handle it, but courts don't usually operate on informal assumptions. Judges want documented proof, confirmed procedures, receipts, lab requests, official results, and when those things aren't available, the explanation starts collapsing. You can also hear Judge Simpson becoming more direct and less patient. Earlier, he allowed long narratives. Now he's interrupting more often, narrowing questions down, and testing contradictions. That's usually a sign the court believes the defendant is talking around the issue instead of answering it directly.
You said when?
He said, yeah, man.
March 11th, you test positive for cocaine again.
Want to still be on my sister now if I did it that early or some type of hair follicle blood.
March 11th, you tested positive for cocaine again for the 5th time.
And all of them, I never did cocaine in my life. And it's hard based off the cases I'm dealing with, but I can't make you believe, but I wouldn't come to court if I violated 5 times. Knowing this.
You know what? You keep talking to me, and that's not going to stop me from doing what I'm going to do, but I'm going to let you go on and get everything out. You then told me that you were sending that one in. And now I find out you haven't even sent that test in. And then you're telling me that I didn't know that it was positive and that you didn't know about this. What you're telling me doesn't even make any sense. You haven't sent that sample back to be tested, have you?
No.
Why not?
Because Mike said he would handle it once he talked to Darren. Because my test came up negative. His test came up.
Well, the PD is going to have to call up and try to figure out what the heck's going on up there and let away then, because I'm just telling you, you don't see this.
Can I ask you a question since you're the judge?
Go ahead.
I just want to know how many active users have you seen drop 8 times a month and drop 30 once? I dropped 30 once since.
How many active users have I seen do that?
Yeah.
Like, man, I've been on the bench almost 25 years. How many do you think?
Like once. I assume they might drop it twice, 3 times.
Let's do it this way. Because I think he's going to have to learn to tell me the truth, because that's not the truth. This doesn't happen. And if you think you're going to get up here and just kind of try to fast talk me into doing something, no, it doesn't work that way.
Judge Simpson just delivered one of the clearest courtroom reality checks of this entire hearing. Maurice Jones tried using logic, emotion, consistency arguments, and personal explanations to persuade the court. But the judge's response boils down to one message: courtroom decisions are not based on fast talking or storytelling. And honestly, This is where decades of judicial experience become obvious. When Judge Simpson says he's been on the bench almost 25 years, he's essentially telling the defendant, "I've heard every version of this before." That experience changes how judges evaluate explanations. They compare stories against thousands of previous cases, not just the current conversation happening in front of them. What also hurt Maurice badly here was trying to debate the judge's understanding of active users and testing patterns. That's risky territory. Once a defendant starts sounding like they know more about drug use behavior than the judge expects them to, it can unintentionally reinforce suspicion instead of reducing it. And then comes the biggest consequence of all, bond revocation. That is massive. Judge Simpson is no longer comfortable letting Maurice remain out under the current conditions while these violations are unresolved.
And why would you know anything about active users and how many times they would drop dirty in a month?
Only because I'd have been in the system.
Cause conference will be adjourned to next week. That's the March 21st, 2024, 9 a.m. Counsel, you can maybe have that conversation about coming before me and telling me the truth, but at this time, defendant's bond is revoked. You are remanded. Yes, sir.
Hopefully you state your name for the record.
That we just did.
You have to state your name.
Jason Travis Pope.
Thank you. My understanding is he's waiving preliminary examination.
Correct.
Is that correct, sir?
So what you wish to do?
Yeah, I got a few questions.
Well, those are probably directed to me, not the judge.
No, that ain't directed to you. You're not my judge. All right, I have a few issues and cases that matter. I was supposed to get sentenced yesterday. They adjourned it. Now, this is a new case that happened during the same string that.
Hold on, you're
Yeah.
supposed to get sentenced where?
Your Honor, he had sentencing before Judge Conlon yesterday. He is correct in saying this isn't necessarily a new offense. It just was charged later. So the sentencing before Conlon was adjourned. The understanding in our discussion is that he was going to waive his right to an exam on this case and try to get it up there to reach a resolution to be
Is that the right
sentenced
way to do it?
altogether.
Is that the right way to do
The
it?
judge can't give you legal
I
advice.
can't, right, I can't give you legal advice, but
That's what you
hang-
do?
Yeah.
yeah, that's exactly why Ms. Apple's here.
Okay.
Yes.
And you should listen to her because she knows more than me.
Okay.
Okay?
Or
Yes,
stretch,
sir.
but thank you.
All right.
I was wondering to waive that right.
Okay, so
Wait.
you'll waive that right. You understand that preliminary examination would be a hearing and you're not gonna have that hearing. And you're gonna go up to circuit court before Judge Conlon with your other case. You
Yes, sir.
understand that?
Yes, sir.
All right.
Yes, sir.
After all that tension, courtroom conflict, and bond drama, this next hearing feels almost like a reset button. But even though the energy is calmer here, the legal stakes are still very real because the defendant is making an important procedural decision, waiving the preliminary examination. Now, for viewers who may not know, a preliminary exam is basically a hearing where the prosecution presents enough evidence to show probable cause that a crime occurred and that the defendant likely committed it. By waiving that hearing, the defendant gives up the chance to challenge the evidence at this stage and allows the case to move directly up to circuit court. What's interesting here is how carefully the judge explains the process. Judge Simpson repeatedly makes sure the defendant understands what rights are being waived and where the case is heading next. That's extremely important because appellate issues can arise later if someone claims they didn't fully understand the waiver.
People also waive their right.
No, you're okay.
Preliminary examination having been waived, defendant is bound over to circuit court on the 2 counts. Ms. Apple.
Your Honor, we would acknowledge receipt of the information, waive its formal reading, stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 27th at 1:30 before Judge Conlon.
March 27th, 2024, 1:30 before Judge Conlon.
Before comment at that time. Okay, all right.
All
Thank you,
right,
Judge.
Bond will
Thanks, Cynthia.
continue.
Have a good one, man.
You do the same. Thank you. Oh. Blondie was here too long because see, Nimish always asks bad time the information. She just walked up.
That's what I did.
That's exactly what she did.
Yeah, I felt like risking attempt at snapping a couple more recalls over.
Yeah.
Okay, because that's.
Oh, I know. Court does call the case, recall the case. People versus Charles Kane Cross.
Assistant Prosecutor Attorney.
Deputy Source, the public defender. Your Honor, I was not able to locate Mr. Kane Cross.
But he was here,
He was here.
then he left.
He left.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000 cash surety. The file will be noted that the defendant was here and then left.
And just like that, Charles Cross turns a courtroom appearance into a warrant situation in a matter of minutes. According to the court, the defendant was physically present earlier and then left before the case was called. That is one of the fastest ways to trigger judicial frustration because from the court's perspective, it looks like someone knowingly walked away from their own hearing. Now, the defense attorney does clarify that Mr. Cross had been there initially, which is important context. But once the defendant leaves without permission and misses the actual call, the court still has to respond procedurally. That's why Judge Simpson immediately moves toward a bench warrant and sets bond conditions. And notice how quickly the tone shifts. There's no long discussion, no negotiation, no emotional back and forth. The judge treats it as a direct failure to appear issue and acts immediately. This is something a lot of defendants underestimate. Courtrooms operate on schedules, appearances, and accountability. Even if somebody has a reason for leaving, disappearing before your matter is called can create serious consequences instantly.
That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case People versus David Rasmussen.
Image Finatra, Senior Assistant Prosecuting Attorney.
Two cases.
Matthew Miller, Assistant Public Defender, with and on behalf of Mr. David Rasmussen, who appears to my right. Can you state your name for the record?
David Rasmussen.
What are we doing?
Your Honor, today's the date and time set for a probable cause conference. I'm going to ask for just a short adjournment. I want to go over the police report with Mr. Rasmussen again. He was just arraigned on a new charge over this weekend, so just
A new felony?
yes.
So we got another case coming up?
Should be the second file on the.
Oh, I see.
This hearing may sound casual on the surface, but there's actually a major red flag buried inside it. A brand new felony charge appearing while the defendant already has another pending case. That changes the courtroom dynamic immediately. The defense attorney starts by requesting a short adjournment to review the police report again with Mr. Rasmussen. But once the judge realizes there's now an additional felony case involved, the entire situation becomes more serious. And honestly, Judge Simpson's reaction here is interesting because you can hear a little humor mixed with frustration when discussing how quickly staff added the new matter onto the docket. But beneath that lighter tone is a real concern courts always have: repeat criminal exposure while already under supervision or facing unresolved charges. For defendants, new charges during an active case can complicate absolutely everything: negotiations, bond status, sentencing exposure, credibility with the court, and future plea discussions. Prosecutors notice it. Judges notice it. Defense attorneys immediately start recalculating strategy around it. What's also notable is that nobody's arguing aggressively here. The defense isn't fighting for immediate action. They're asking for time. That usually means counsel needs to fully assess how the new allegations interact with the original case before making major legal decisions.
Your staff was very responsive to the request of the public defender to add it to today's docket, so they did that.
Oh, don't do that again. Never mind. You had a couple weeks out there?
Yes, Your Honor, that'd be nice.
Probable cause conference, March 28th, 2024, 9 a.m. Bond will continue. Thank you. Recalls case of the people versus Sandale Burns.
Mr. Sinatra, Senior Assistant Prosecuting Attorney for the People.
From the Defender's Office on behalf of Mr. Burns.
Burns, can you state your name, please?
Sandale Burns.
Okay. Got it. Okay. What are we doing?
Your Honor, an offer has been extended and I have been working with the prosecutor regarding this case. We are going to ask for, I believe they are going to ask for a brief adjournment.
I'm not asking for an adjournment. I know defense is asking for a plea. And I said that I had to check with the victim.
Got it.
For that happens.
So you're requesting an,
Then I will
you're
request
requesting an
adjournment
adjournment so they
so
can
that
check.
he can check with the victim regarding whether or not that offer is acceptable.
Thank you.
Probable cause conference, April 4th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank
I'm
you,
going to
sir.
call you, Mr. Burns.
Okay, thank you.
Case People versus Todd Salsbury.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Salisbury. Salisbury, would you please state your name for the record?
Todd Michael Salsbury.
We're asking that this case be set for a preliminary exam.
Discovery complete.
It is.
Would the people have their witnesses available on the 26th?
Yes, Your Honor.
Preliminary examination will be set in person March 26, 2024. 9 a.m. That's before me.
Your Honor, may I address bond very briefly?
Sure.
I'll make it brief. The court's very aware of Mr. Salisbury's situation. We are just asking the court to consider a 10% option on the bond that is currently set.
I denied the bond reduction the last time out. I don't see anything necessarily that's changed. So I'm going to deny the motion for bond reduction. I'll certainly reconsider it after I hear the preliminary examination or at the time of preliminary examination.
Understood. Thank you.
Thank you.
Todd Salsbury's hearing gives viewers a perfect example of how bond reduction requests actually work in real life. Defense counsel asks the court to consider a 10% option on the existing bond, and you can tell she's trying to build off the judge's familiarity with the defendant's overall situation. But Judge Simpson immediately focuses on something judges care about constantly. What has changed since the last denial? That question is huge, because courts generally want a material change in circumstances before reconsidering bond conditions. And when the judge says he doesn't see anything that's necessarily changed, that's essentially the entire ruling right there. The court isn't saying the defendant is hopeless. It's saying there's currently no new information strong enough to justify reducing the bond risk.
Case People versus David Copeland.
Ready in that matter. Lauren Brown, Deputy Chief Public Defender, opinion on behalf of Mr. Copeland. We were able to get in contact with Mr. Copeland. He was unable to arrange a ride. He should be by Zoom.
He was unable.
Should be on by Zoom.
Yeah. He was unable to get himself here?
Yeah, he could not arrange a ride, so he did the next best thing, got it by Zoom. That's
all right. Okay, Mr. Copeland, my understanding is that there may be a withdrawal coming in, or no?
So, yeah, that's a correction, Your Honor. There was a Davion Copeland that we had to withdraw from. I think there was some kind of confusion as between the two. So
got it.
Not withdrawing.
You're not withdrawing on this one. Okay.
Continuing our representation.
So you need an adjournment, however?
We do, yes.
All right. Mr. Copeland, I'm going to grant the adjournment I'm gonna adjourn your probable cause conference to April 4th, 2024,
that-
9 a.m.
That person, that one will be in person?
Yes, sir.
Okay, I'll make sure I have a ride, arranged for that
Okay.
one. I assumed this morning is
All
why I
right.
didn't have a ride. I apologize.
No, it's okay. Thank you for the note.
This interaction with David Copeland is one of the more human moments in the entire docket. Instead of chaos, arguments, or violations, the issue here is surprisingly simple: transportation. The defendant couldn't arrange a ride to court. Now, some viewers might think that sounds minor, but judges hear every excuse imaginable, so credibility still matters even in situations like this. What helps Mr. Copeland here is that communication happened beforehand. The court already knew there was an issue instead of just dealing with a total no-show situation unexpectedly. You can also hear Judge Simpson handling this differently than the earlier failure to appear case involving Charles Cross. That contrast is important. One defendant left before being called and triggered an immediate warrant. Here, the defendant stayed engaged with the process, acknowledged the issue, apologized directly, and confirmed future attendance plans. That difference in attitude can completely change how a courtroom responds. And there's another subtle detail here too: confusion involving another Davon Copeland and a potential withdrawal issue. Court systems process massive numbers of cases, and similar names can create procedural confusion fast, which is why attorneys clarify representation issues immediately on the record.
All right. Take care, Bond. We'll continue.
So that's
Thank you.
April 4th, Your Honor.
Yes, sir.
Thank you very much.
Court calls the case of the people versus, is it Mikos Talk?
What an incredible stretch of courtroom moments this turned into. Across this entire docket, Judge Simpson handled everything from missed drug tests and disputed cocaine positives, all the way to bond revocations, failure to appear warrants, preliminary exam waivers, and active plea negotiations. And through every hearing, one theme kept showing up over and over again: credibility. For Miss Exton, the issue was whether grief and personal hardship explained a missed test while still preserving the court's trust. For Maurice Jones, the courtroom battle became much larger: repeated positive cocaine tests versus a defendant insisting every result was wrong. And once Judge Simpson decided the explanations no longer added up, bond revocation followed immediately. Meanwhile, other defendants showed how differently the court reacts depending on communication and accountability. Some received adjournments and continued bonds because they stayed cooperative and transparent. Others faced warrants or stricter consequences once the court believed compliance broke down. And honestly, that's one of the biggest lessons from this entire courtroom session. Judges are constantly evaluating reliability, honesty, and follow-through just as much as the actual legal allegations themselves. Judge Simpson also showed viewers something important about courtroom leadership. Even during tense exchanges, he repeatedly slowed proceedings down to confirm rights, clarify expectations, and explain consequences directly on the record. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.